Welcome to the Cox Yeats Podcast, where we break down legal topics that matter to you. Cox Yeats is a dynamic law firm with offices in Durban, Johannesburg, and Cape Town, known for practical insights and real-world legal expertise. In each episode, we dive into honest, in-depth conversations with the people behind the practice, sharing what they're seeing on the ground, what clients are asking, and how the law is evolving. In this episode, we sit with Peter Barnard, Chantal Mitchell, and Claudelle Pretorius. Peter Barnard is a partner in the construction and engineering law practice area. Peter has practiced as an attorney in South Africa since 2012 and is widely recognized for his leadership in construction and procurement law across Africa. He has acted for major developers, contractors, consultants, and suppliers in complex litigation, arbitration, and adjudication matters, and is highly regarded for his in-depth knowledge of contracts like JBCC, FIDIC, NEC, and GCC. Peter coined the term construction mafia and was the first attorney to take interdict proceedings against a business forum. He regularly shares insights with industry professionals, speaking at leading organizations including the Master Builders Association, the Association of Arbitrators, the Association of Quantity Surveyors, and the Association of Architects. As a recurring member and the chair of the JBCC Drafting Committee and co-author of a practical guide on construction contracts, Peter continues to shape legal discourse in the built environment. Claudelle Pretorius. Admitted in 2019, Claudelle has extensive experience across South Africa and the continent, having acted in international arbitrations under ICC and UN Citral rules. Her practice spans high-stake disputes in construction and procurement law, and she's been recognized as a standout contributor in her field. With a strong commercial mindset and global outlook, Claudelle brings valuable insight into the complexities of construction law today. Chantal Mitchell. Admitted in 2018 and made partner in 2021, Chantal specializes in construction, procurement, and engineering law. She's known for handling complex disputes involving major infrastructure projects, interdicts against site disruptions, and navigating tender appeals and high court reviews. Chantal's sharp litigation skills and deep knowledge of contracts like JBCC, FIDIC, NEC, and GCC make her a key player in South Africa's built environment legal space. So we often hear of this term scope of works. Chantal, what is a scope of work?
The scope of works is what the contractor is obligated to do in terms of its contract. So if the contract is to design the building, then the scope of works would be for the professional team to prepare the drawings, get necessary approvals of those drawings, and proceed to sign off. If the contract is merely to build the works, then the scope of works is actually contained in the drawings and any instructions issued to the contractor by the professional team. Often what we have found, however, is that the scope of works is not adequately defined in the tender or adequately defined at the start of a project or in the contract that is issued to the contractors. Often in the public sector, tenders go out too soon. There is a rush by government to get a tender out because they have an obligation to utilize the finances, proceed with what they've told the public that they are going to proceed with, and issue tenders to use up the budget. However, if they go out to tender too soon before they have properly understood exactly what they need, sometimes they go out to tender before the designs have been finalized and prepared to approval stage. So they'll go out to tender on preliminary designs and not final designs. And as a result, the scope of works is not fully defined. And in those instances, they will ask for contractors to simply price a provisional sum. Now that is just a budget provided. So for example, if they're needing a kitchen built, they will provide a provisional sum of 500,000 Rand for that kitchen without properly understanding exactly everything that's going to be needed.
What needs to go into the kitchen.
What needs to go into the kitchen. So next thing it turns out they want some fancy countertop that's going to cost them a significant amount more, and then the project can end up costing them a lot more, and then there's significant scope changes that have to happen and price increases that have to happen. And that is actually the purpose of what we're going to discuss today. What is important to understand is that the scope is not the price. It is not contained in the BOQ. That is not your scope of works. The scope is what is contained in the drawings, what is contained in the contract. It is the site information, the contract information.
Okay, and why is it so important? Why is it not contained in the bill of quantities?
So the bill of quantities are your rates. They are remeasurable items in a contract. So, for example, if you tender, if you contain in your bill of quantities a price for 500 bricks and you only use 100 bricks, you're only allowed to, then your scope of works was 100 bricks. It's not 500 bricks, which was originally in your bill of quantities. You would only be entitled to you'd only be entitled to charge for the 100 bricks that you brought onto site. So that is why it's not, the bill of quantities is not actually your scope of work.
When there is a change to the scope of works, you would refer back to the bill of quantities in order to price that change.
Yes, so the bill of quantities is used to price. It is not used to determine the scope of works. Changes to scope of works are issued externally from the bill of quantities, and then the bill of quantities is utilized to price the cost of the change.
Of course, something we're going to have to come back to later is situations where a new item of work is added in that's not contained in the bill. And invariably that leads to problems, because then you have to try and work out, well, how much did the contractor get paid for that? And you can't refer back to the bill because it's not in there.
Right. Okay, so when does a change occur to the scope of works?
A change to scope of work would occur when a variation order is issued by the employer's agent, or if the contract doesn't necessarily provide for employer's agent, by the employer itself.
Peter, could you maybe guide us with some circumstances where there would be a change to the scope of works?
There's a myriad of reasons why a scope of work can change. Chantal hit the nail on the head with one of the first ones, and that is that government has to put projects out to tender simply too soon. In an absolute nirvana, a project would be fully detailed with every single drawing being prepared before the project goes out to tender. That is simply not possible and doesn't work in the industry. So Chantal says projects go out too soon, almost in a rushed manner, especially in public sector, where the final design is not yet ready. So what can happen is during the course of construction, an employer can see that what they originally intended doing is not going to actually be fit for purpose, and that can result in changes having to be made so that the design can ultimately be rational and work for what they're trying to achieve. Other scenarios can arise. For example, an employer may have to divert funds from one project to another project, and all of a sudden the project for costs have to come down because they just don't have the funding available. You might have instances where a specific type of material or a specific item, for example, an overseas mechanical item, HVAC, or some kind of plant or equipment that is specifically needed for the running of a live site, is going to be brought on, but now all of a sudden that item can't be imported. Now all of a sudden something has to change and a different item has to be used. That can change the whole sequence of work. That can change when you put up walls, how the foundations have to be put in, etc. So the availability of materials and goods and plant, etc., can also have an impact. We also see sometimes that the employer has a very limited or fixed budget. And in those circumstances, if there's delays to the contractor, and those delays result in the contractor being able to claim additional time and costs, all of a sudden, more of the project budget is going towards the contractor's P's and G's, and that results in less money being able to go into the project. Well, that means the employer then has to do budget cuts effectively to try and make the budget work. You'll also find, for example, in health, the Department of Health will come along towards the end of a hospital being constructed, and they may want changes because of their obligations. And therefore, things have to change, which can push up the price. You may find that halfway through a build, the employer is feeling particularly opulent and all of a sudden decides they want an extra story on their house, an added swimming pool, perhaps upgrading that swimming pool to an infinity pool. These things happen. You can also have certain situations where, for example, halfway through a build, the employer decides that actually the anchor tenant that was going to go into this premises is no longer going to be going in. So, hypothetically, Pick n Pay is changing to Woolworths. If you're talking about a shopping center, for example, in those situations, they'd have to change because, of course, your anchor tenants in a commercial retail space have a very set look and feel. If you go to a Zara in Cape Town, you go to a Zara in Durban, they have the same look and feel. So that kind of thing can also change it. So there's a variety of reasons that projects can change. And what we find is that often those changes have unintended consequences that the employers can't foresee, at the time that they make them, which can lead to all sorts of disputes along the way.
Okay, right. So on that note, where there is a change in the scope of works, how do the standard form contracts provide handling these changes?
Under the JBCC, changes are issued through contract instructions, which can either be issued by the principal agent or the employer if the principal agent doesn't have the authority to issue those instructions. Variations are priced in terms of clause 26 or 32 of the JBCC, depending on which version of the JBCC you use. So the first way to price a variation would obviously to look at the rates that are contained in the bill of quantities, and Chantal's already touched on that. If you can't use the rates in the bill of quantities, but the item is similar to a rate contained in the bill of quantities, then you use that rate and you adjust it slightly so as to accommodate for that change or for the difference in the item. The third thing which you can do is you can provide the employer or the principal agent with a quote, and that quote can get approved. If none of those three scenarios apply, or if you're unable to get approval of a quote, then the fourth scenario is you are able to claim the actual costs incurred for the change plus your markup. And the markup is usually around 5 to 10%, depending on the contract and what's agreed, but in most standard form contracts, it's 10%. Then FIDIC works a bit differently. So FIDIC has a variation clause, I think it's clause 13, and under the FIDIC contracts, the employer can either issue a variation or request a variation. If the employer requests a variation, the contractor will have to submit a proposal to the employer, and then there can be a bit back and forth. If there's no agreement on the pricing, then the exact same techniques that are used under the JBCC would be used under FIDIC. So it makes provision for using your bill of quantities, adjusting your bill of quantities, agreeing on a price, or cost plus 10%. Another option which exists under FIDIC is that the contractor can actually make a proposal to the employer. So if the contractor finds that something on site is not working, or that the design is defective, or they can't obtain a particular item for the build, they can propose an alternate design or an alternate item. And then they can try to get the costs approved. If there's no agreement, then you'd follow those 4 scenarios I just spoke about.
I think what's important under FIDIC, and I don't think any of the other 3 standard form contracts cater for this, is that often when there's a change to the scope of works, that can also have time implications, which can have P&G implications. So what FIDIC specifically allows for is that when a variation is being discussed, you don't just discuss the item of work. There is also an opportunity, without having to make an extension of time claim, that when you are discussing that item of work, you simultaneously discuss the additional time that's going to be required and the associated costs, which gives the employer a lot more certainty that when they agree to this variation, they know all of the financial consequences, as opposed to approving the variation, adjusting their budgets internally, and all of a sudden getting hit with a claim for more time and more P's and G's that they didn't originally anticipate.
So if the contractor provides a quotation for that variation to the scope of work, and the project manager, that is effectively the employer's agent in the NEC contract, the project manager doesn't respond to that quotation within a specified time, I believe it's 2 or 3 weeks, the contractor's quotation is deemed accepted, and the contractor can proceed with that variation, proceed with the scope change, and then claim the price at the end of the contract based on the quotation that it provided. That's quite different.
The costs are approved as well if they don't respond.
Correct, if the project manager doesn't respond.
One of the fascinating things with NEC is that all of the other contracts provide for a situation where if a contractor claims and the claim or the notice is not responded to, that claim is deemed rejected. But under NEC, when you claim a compensation event and you don't get a response, you send a follow-up. If that's not responded to, the compensation event as a concept is deemed approved. That could be a delay, that could be an instruction, etc. Then as Chantal's saying, you send a quote. If they don't respond, you send a follow-up. That's also then deemed approved.
But it's important to distinguish that that's in events where you've been issued with an instruction to proceed with the variation. It's not in a situation where you're
the
still
contractor is
discussing
proposing the variation.
or where you're in discussions about whether to implement that variation and you've been requested to provide a quote for consideration. So that's another process by which variations are implemented under the NEC. GCC also actually has a similar process where you can get instructions implemented and accepted without them being necessarily issued. But that's where an oral instruction has been given to you on site by the employer's agent. And what the contractors then may do is issue a notice to the employer's agent and the employer stating, I confirm that you issued me with this instruction. And if the employer's agent doesn't respond rejecting or objecting to that within, I think it's 3 days, it's quite a short period of time. If they don't then respond objecting to that, then that instruction is deemed an employer's agent's instruction, and it comes with the necessary consequences with that. So if you get given an instruction while on site to change the scope of works and you confirm that in writing and there's no objection received from the employer's agent, then that is a deemed instruction and you can proceed with it and claim and make the necessary claim.
That's interesting because under the other 3 contracts which we've discussed, your instructions must be issued to you in writing. And if they're not issued to you in writing, they're not binding. Under the JBCC in particular, the instruction will be issued to you in writing and you're then obliged to comply with it within a reasonable time. If you don't comply with it, then a further notice is issued to you. And if you still don't comply with it because you're concerned about agreeing on the costs, then the employer can actually appoint someone else to do that work and
claim the cost from you.
Claim the cost from you.
And the JBCC is interesting because unlike the GCC, it specifically says that an oral instruction is of no force and effect. In that sense, I think the GCC is a bit more practical because things happen. You get told to do things, you're rushing around. And to me, it makes sense that you as the contractor would then write to the employer's agent and say, listen, you told me to do X. I'm just confirming that you want me to do X. And if you don't hear back, then it's deemed approved. I do think that's a good way of doing it because things obviously are going to happen on site orally. And I think to just blanketly suggest that an oral instruction is of no force and effect, I think that's impractical. Makes sense that it has to be confirmed in writing.
Okay, so going back to where a contractor wants to propose a variation to the scope, what are some examples of reasons for why this could occur? I remember Peter mentioned something about if a contractor itself is delayed. Would that be a reason to approach the employer then for a variation to the scope? And how is this dealt with?
So you can have a couple of situations, not so much on scope, but some of the contracts cater for a situation where if a contractor is falling behind, then they'll be specifically instructed that they have to catch up. If a contractor has fallen behind because of delays that it's experiencing on the site, then rather than be given an extension of time claim, an employer will say, listen, I have to meet this deadline. The hospital has to open in accordance with my hospital license. The anchor tenants have to start trading in the shopping center, etc. I'm not going to give you additional time. Instead, I'm going to instruct you to accelerate, which would be the antithesis of an extension of time claim. So rather than having more time, you have the same time, you've got to pull longer shifts, bring in night staff, etc. That obviously has cost implications. But you don't often get a change to the scope of works because the contract is falling behind. That'll just be more of an instruction regarding timing. A change to the scope of works will typically come about either because of budgetary constraints on the employer's part or because something has to change to the project itself, or like we debated earlier, things aren't practically going to work in terms of the design. Provisional sums have come in and now the employer's actually started workshopping what it wants, and then it starts having to go into more detail.
So where an employer has instructed a contractor who's fallen behind to accelerate, even if it's through the contractor's own fault, does the contractor then get the costs associated with that?
If the contractor has itself fallen behind, then that would be seen as remedial work or self-acceleration, or in order to bring itself back up to the current version of the latest accepted program. If the contractor's been, so let's end that thought, the answer is no financial consequences because they're having to fix. They're having to self-remediate. If it's a situation where the contractor has or should be given additional time, but the employer just can't give them the time, and the contractor has to accelerate to help the employer out, that obviously comes with additional costs.
So, in the public sector, where there's a variation to the scope of works, what problems can arise from that?
With government departments, they are allocated a set budget for projects. And where there are scope changes, specifically where the scope of works increases, they obviously need additional costs and an additional budget for that scope change. There's generally about a 10% contingency allowed for scope changes. However, where it extends beyond that 10%, it becomes relatively problematic. And what we are often finding is that for government projects, they will include a caveat that where a variation order results in an adjustment to the contract price of more than 10%, it requires Treasury approval, and that the contractor mustn't proceed with the change until such time as Treasury approval is issued. Now, where the change to the scope of work is required in order to proceed with the works, that can often result in the entire project coming to a standstill, everyone just sitting, and it results in an extension of time claim for that entire period that everyone is just sitting. And Treasury approval can take months. We've even seen it take years. So often what ends up happening is you have to wait till the new financial budget is issued and to be allocated more funds from Treasury. And so you could end up having to wait for a whole new financial year before the project can proceed any further.
And I mean, while they're sitting, they've got all these P's and G's.
All the additional costs and P's and G's can get allocated to them. And also where works comes to a standstill, it can cause additional problems for the actual works itself, that if there is any rebar sitting out, it can be damaged by weather and other issues like that. So these Treasury approvals, the requirement that variations to the scope of works can only occur where there's Treasury approval can cause significant problems to the works.
We had a really interesting case on that issue where a principal agent had a book that they would write all the instructions in. And it was just a book with templates, and they would write in, do this, do this, do the other. And then all of a sudden, they weren't paying the contractor for all these variations, and that's where we got involved. And then it turned out that in that book, on the template, in fine print at the bottom, as Chantal was saying, was fine, tiny little writing. If this instruction is going to result in a financial change, you do not proceed unless you get approval from us. But the contract didn't talk to, in this case, it was a JBCC. So it wasn't like a GCC or a FIDIC or an NEC where you are, in some instances, forced to try and agree. Because as Claudelle mentioned earlier, you can just use the bill, adjust the bill, or go cost plus if you don't agree. So in this instance, the contractor was simply proceeding. Then the employer said, no, I didn't give you the instruction to approve because even though I told you to do the work through my agent, we didn't agree on the price because of this fine writing. That then led to a whole dispute because what is supposed to happen? If the employer says, don't put the wall over here, move the wall 5 meters to the right so you can extend the space of this room, and that for some reason comes with cost implications, are you then supposed to proceed with the original wall while you're waiting for approval and then knock it down and redo it? And that has other budgetary constraints. So we ended up winning that case on the basis that that print was too fine and that ought not to have been considered because they didn't tie up with the contract. And it wasn't effectively a qualified instruction. But these are the types of things that can happen. So an instruction can be given, but where it's not yet approved, you then have to proceed with the original scope of works. We have another case right now, funny enough for the same client, where the employer said, well, until such time as I approve or reject that instruction, the original scope of work should have been carried out. So in this instance, the contractor was waiting for 2 or 3 months because it knew there was going to be a change to the scope of works. The employer then saw that this was going to result in an extension of time claim with P's and G's, thought they'd get clever, and omitted the instruction. And then said to the contractor, well, now you've got to pretend that the instruction was never issued, and now you yourself are actually just 2 months behind in your program, and you should have been carrying on with the original scope. We're having to make the argument that it would have been fruitless and wasteful expenditure on government's part if the contractor carried on with the original scope, knowing that they'd been instructed to change the scope, and they were simply waiting for that instruction to be given effect to from a pricing point of view.
I think the main problem with respect to that is that legislation and building contracts don't exactly tie together very well. They don't marry each other. Municipalities, for example, are obliged to comply with the terms of the Municipal Finance Management Act. And in terms of that act, the municipalities actually can't incur expenditure unless it has achieved approval from provincial treasury, and then provincial treasury may need to obtain approval from national treasury. So
Is that always, sorry to interrupt, is that always written into the contracts? Is that variation process always included, or do you have a scenario where that's not catered for in the contract at all and yet?
Yes. So more often than not, that's not written into the contract, but that is legislation which the municipalities and the departments have to abide by. And if those processes are not followed, then you could have issues down the line where the decision taken to approve a variation order or issue an instruction was not actually authorized and can be set aside.
And it can get more complicated because even though the principal agent issues the instruction to do the work, if you then do the work, you don't know what's happening with their budget approvals behind the scenes. And then all of a sudden they tell you, yes, but the contract says you have an obligation to comply with the law. And the law says that this work, and then you have to say, well, hang on, that's the law, but that's the law that applies to you. And obviously all law applies to everybody, but in this case, that's legislation that specifically governs, as Claudelle says, how municipal, provincial, national departments operate. So if they're the ones that are required to get approval, then frankly, they should be liaising with their consultants, their professional
Before
team.
ever issuing the instruction.
Before ever issuing the instruction. That's exactly right. Another problem that we then encounter is that an instruction will be approved. The cost, let's say for this scenario, is known, and the employer then thinks, well, I can now budget for this additional cost because I know exactly what it's going to be. Then all of a sudden, afterwards, the contractor then decides to make an extension of time claim and wants an additional few months' time and additional few months' P's and G's, which can push the price up further, which can potentially lead you into a death spiral because now all of a sudden the VO has been approved with the cost, but not the time with the cost. So if there's going to be further budgetary implications, do they then have to go back and get those costs approved? And if that additional time and associated cost hasn't been approved, do they carry out the instruction in the first place? So that can be an ongoing issue. What we see in response to that is that more often than not, the professionals who are not acting like true independent consultants as they ought to, but instead are acting like hired guns, will try and dismiss the extension of time claim on the basis of, well, this work was taking place concurrently with other work, or, well, this work wasn't on the critical path. So even though I've given you this instruction to do all of this additional work, I'm not going to give you any additional time, and I'm not going to pay you any additional preliminary and general costs because, you're on site, you may as well get it done at the same time.
Peter, so you mentioned that an employer may not grant an extension of time claim if a delay arises that's not on the critical path. What is the critical path? Could you explain that a bit?
There's a few programming concepts which come through, which obviously go to the heart of extension of time claims. So like I said earlier, one of the key features is that an employer may say, well, you're already on site doing this work, so who cares if I give you more work to do? I don't need to give you more time. That's not how it works. The critical path is effectively the item which starts the project and then creates the golden thread going through to the final item of work to be completed. So if an item of work is going to have a knock-on effect, which is ultimately going to push out the final item of work, which accordingly pushes out the completion date, that is then the critical path. To use a silly example, if you've won the lotto and you're building some luxurious house and you decide you'd like to add in a swimming pool, the swimming pool can be done pretty early on the job. It could be done at the middle of the job. It won't impact anything else because the house is still getting built and the pool won't impact it. If, however, you're right at the precipice of practical completion and then you decide you'd like a swimming pool built, well, the only thing that's preventing the contractor from getting a certificate of completion is the swimming pool. In that instance, the pool would be on the critical path. But given that it could have been built at any stage if the instruction was given earlier, then it won't be on the critical path. So it's then difficult to try and assess if a contractor should be given an extension of time claim or not. If an item of work could be carried out concurrently and somewhat independently of other items of work, then it won't be on the critical path. But if a new item of work is added in, which then has a knock-on effect or prevents other items of work from being completed on time, which ultimately pushes out the completion date, that's on the critical path.
Should result in additional time being given.
That should result in additional time being given. One of the main issues we see is that an employer or principal agent will say, well, yes, this will take you additional time, but you yourself are delayed. And because you yourself are delayed, I'm not going to give you any additional time.
So that's one of the most frustrating and common responses that contractors receive to their EOT claims and projects. And I think we've spoken about this multiple times, and no matter how many times we've indicated or advised contractors and employers that where there are two or more causes of delays that affect the critical path, the contractor can still be granted an extension of time claim. So if the contractor is delayed on one item of work and the employer instructs the contractor to execute another item of work and the contractor makes a claim for that item of work, the contractor should still be awarded the additional time he's claiming. A claim cannot be rejected on the basis that the contractor is already delayed.
It's premised on this English principle called the prevention principle, which effectively means that the employer is obligated to provide a contractor with a reasonable amount of time to perform the works, which means that even if the contractor is delayed itself, if the employer issues an instruction to perform additional work, it needs to afford the contractor a reasonable amount of time to perform that additional work, regardless of the fact that it is late itself. It's termed the prevention principle because the employer cannot effectively prevent the contractor from completing the works within a reasonable time by failing to give it a reasonable time within which to do the work. What we often find where contractors seem to get a little bit mixed up is where they wouldn't factually have been delayed by the instruction. That is where the critical path element becomes extremely important. The first question always is, does this instruction or does this event factually cause a delay? That is, you have to consider, would it have factually required additional time to perform the work? So where the instruction is for an ancillary works that needs to be performed, and it doesn't actually fall on the critical path, and it is being performed then concurrently, you're not automatically entitled to the additional time just because it's an event that would have entitled you to an additional time if there had been no other works being performed. It had to have factually caused a delay. So even if you are delayed yourself, if it falls on the critical path, had you not been delayed yourself, it would have caused a delay and you would have been entitled to additional time. But where it's being performed concurrently, and if you even, let's say you'd been performing your works and you were on time, and you received an instruction to perform that additional work, if you could have done that additional work still within your original contract period and it wouldn't have caused any delay, then you're not entitled to an extension of time. So it's actually a factual question, and sometimes I think clients and contractors forget to add that factual element into the question.
I think one of the biggest problems also is that when they make an extension of time claim, in this case, what we're talking about coming on from a variation, is that to justify the additional time, they'll attach a program, but they'll attach a program which was concluded originally at the time the contract was signed, which then becomes completely out of date because events have moved and things have changed and work has been added and omitted. It's crucial that when you're asked to do additional work and you're making an extension of time claim, you have to attach a program which is live and relevant, or in the wording of some contracts, approved, as at the date the claim is made. It doesn't help referencing a baseline program which is long since outdated. On the flip side, we'll also see employers, agents, principal agents, etc., suggesting that the contractor is not entitled to receive any additional time because the intended practical completion date has already passed.
So the onus is always on the contractor to prove that there was no concurrency if he wants to get the additional time.
As we're saying, you'd have to demonstrate that it was on the critical path, one, and secondly, that it would delay him more than he is already delayed. Or Chantal says if he's on track, contractually, that it would extend the contract period. If it's work which he could carry out, which isn't going to make him any quote unquote more late, then he won't get that additional time.
To add on what Peter was saying, sometimes a principal agent or an engineer or the employer will reject a claim on the basis that the intended date for practical completion has already come and gone and the contract is already delayed. But a claim can't be rejected on that basis. Your date for practical completion is the date on which the practical completion certificate is issued. Any other date before that is the intended date for practical completion, and a claim can still be made after that intended date has come and gone.
And I think the corollary is also true, that a contractor will automatically assume that they're entitled to an extension of time claim if an instruction is issued beyond the intended practical completion date. But if they themselves are months behind, they're going to miss that date. That doesn't automatically trigger an entitlement either. So it does cut both ways.
So, Peter, in summary, what are the main things to consider when there's a change to the scope of works and delays to the project?
I think the first main thing to bear in mind is whether the instruction to do the additional work is an out-and-out instruction, whether you must go ahead with that work, or alternatively, as we were talking about earlier, whether you have to try and price that work and get approval because of government policies before executing it. You also want to have a discussion with the professional team about what you do until such time as that instruction is approved. Do you wait and make an extension of time claim, or do you carry on with your original scope, which can result in abortive costs? It's also helpful if when there is a change to the project, you can be sure on the price and the time implications. And of course, the time implications have the associated P&G implications. And if you can't, and you know that additional work is coming, you need to understand from a contractual point of view as the contractor, whether you can make an extension of time claim, whether it's going to be concurrent, whether it's going to lead to prolongation, and whether you'll be entitled to make that claim, or whether you yourself are behind and are not going to be able to make an extension. You also have to be clear from an employer point of view that when you approve a variation, it's not just the scope of work and the associated costs. There may also be time and P&G implications you have to think about. And that should be borne in mind by an employer before the variation is given effect to.
Well, thank you so much for having this discussion with us today. Thank you to the Cox Yeats team for this insightful discussion, and thank you for joining us. Please share this episode if you found it insightful.